First District Court of Appeal is now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. All right, good afternoon and welcome to the First District. We have two cases this afternoon. We're going to just take in order. The first case is Janvier, if I'm pronouncing that correctly, hopefully your client's name, versus the Florida Agricultural and Mechanical University Board of Trustees et al. 15 minutes per side. Are you ready, counsel?
May it please the court, I'm Joe Little from Gainesville, and I represent appellant Swana Jean Janvier in this appeal. I'd like to reserve 5 minutes for rebuttal. The appellant respectfully requests this court to reverse the judgment before it and remand with directions to the trial judge to enter judgment for appellant and to provide other proper relief. The defendants, the appellees, excluded the appellant from attending the faculty meetings of the faculty of the College of Law of Florida Agriculture and Mechanical University, which I will hereafter refer to as FAMU, conducted on August 19 and September 2 and October 5, 2020. In all of these meetings, FAMU law faculty conducted or discussed official business on matters that FAMU had delegated to FAMU law faculty, including recommending approval of candidates for the award of FAMU law degrees to the president and to the board of trustees of FAMU.
Well, counsel, could I ask you if you could direct us specifically to that delegation of authority to the faculty and how that delegation makes this a public meeting?
The delegation is made a public meeting by the fact that it is requiring the faculty to make a decision that would be finalized by the Board of Trustees of FAMU Law. It's a decision that is required by the regulations of FAMU Law and FAMU that the faculty make the recommendations of approval for candidates and honors.
But Professor, didn't the dean and others, though, have affidavits that said that there were no decision-making going on? This was just fact-finding for furtherance of policy-making down the road.
They said that, Your Honor, but the affidavits don't overrule law.
But what's the contrary evidence such that summary judgment shouldn't have been entered?
The contrary evidence is that the regulations of the Florida A&M University require the faculty approve candidates for graduation from the law school. That's what the regulation is. Now, what is behind that? Well, if you look at Section 104.40, subsection 2 of the Florida statutes, it states that the FAMU law, specifically FAMU law, shall operate pursuant to the accreditation standards of standards of authorities in the United States that apply to law schools. This includes ABA and American Association of Law Schools, both of which require that the faculty be the policy-making body of the law school, including recommending candidates for degrees. That's where it comes from.
If FAMU was not complying with that accreditation standard, that may put them out of standards, but does that make this a public meeting?
It does, Your Honor, make it a public meeting because, in fact, FAMU does offer its candidates for admission to the Florida Bar, and the Florida Bar requires that every lawyer, standing where I'm standing, sitting where you're sitting, be a graduate of an ABA accredited law school. And that's a rule or regulation of the Florida Supreme Court, which is law, subject to Article 5, Section 15 of the Florida Constitution. That's the regulation. I think it's 1-13.1 and 1-13.2 of the regulations pertaining to the admission to the practice of law in Florida.
Can I ask you, Professor, the ABA accreditation issue, was that argued before the motion for rehearing, or was that only argued on rehearing?
It was argued throughout the case, Your Honor, in the motions practice and also at the hearing and also on rehearing.
So what if the faculty is given the authority to approve a new course, local government law, and they want to have this new course, and they have a faculty meeting and they say, we like this idea and we approve it. Is that open to the students as well, or the public generally?
Is your question, is the meeting open to the student body?
Yeah, for a curriculum decision about, well, what courses are we going to have?
Yes. Yes, because one of the things that have been delegated to the faculty of FMU law and all the law schools in Florida is the development of the curriculum. They have the final authority to develop the curriculum, always subject to the review, perhaps, of somebody else. But as you well know, in Wood against Marston, the Supreme Court of Florida said, contrary to the holdings in other states, every step in the decision-making process, if it has the effect of narrowing the decision to be made by the ultimate decision maker, has to be open to the public, because that's the strength of the Florida Public Records Law or Open Meetings Law, is that the place where the decisions are made has got to be open for public view and perhaps participation, but public view.
Help me with this. I see different layers of authority. You have the university, you have the law school, you have the faculty. And here we have, it's a law school faculty meeting, right? It's not a meeting of the university generally. I get the impression from what you're arguing is that your argument is that the university, not the law school, but the university has somehow delegated authority to the law school and thereby further delegated to the faculty. Help me out. Marston case, I get it. Woods versus Marston, I understand it. I think I was in school back at the University of Florida back then. So help me.
Wasn't too long, wasn't too much before your time.
No, it was in the 80s, so I'm going to leave it there. But help me out on this idea of where the delegation must come from before the public meetings laws apply. I get it if the board has authority to hire a dean and they've delegated it to a faculty subcommittee and the faculty subcommittee, I get that. That's Woods versus Marston. But where here is the authority from the board? You've sued the Florida Agricultural Mechanical University Board of Trustees. What delegation have they made?
Presumably, Your Honor, the Board of Trustees of a university has the authority under the Constitution to make policies of all kinds for the university. The Board of Trustees delegates authority. In this case, delegates specific authority to the FAMU Law School to develop curriculum and the other provisions of the administration or the policies of the law school. It's possible that the university might say, okay, you make provisions for the curriculum, and you'll send them up to maybe a faculty curriculum committee, which will approve them or change them. And they could send them up to the Board of Trustees, which could approve them or change them. So that is the process. Now, when in fact the delegation is of the final authority, or the authority is never questioned, then the person or the body making the decision is the final decision maker. And our provision, our submission in this case, is that the decisions being made by the faculty of the College of Law are decisions that are subject to review by somebody else, but they are required as a part of the process of decision-making.
Well,
And it's,
how then, Professor, do you respond to FAMU's argument that even, a hallway conversation, somebody talks to the dean, hey, Dean, I got a great idea for next semester. I mean, taken to the extreme, that's, the first step in the decision-making process. So would that need to be public record too?
Your Honor, that question is not before the court in this matter, because everything before the court in this hearing was done in an official meeting of the board. The question that you're asking is a further question. Is it a violation of the Sunshine Law for two members of the faculty to have a private discussion about something that may become before the board? And that's an interesting question, Your Honor. The Supreme Court of Florida, in fact, has taken the position that it doesn't matter how inconvenient it might be, the imposition of these regulations. That's what the law requires. And that's what the law requires in this case, Your Honor.
Well, could you tell us specifically, and I know you're going into your rebuttal, we'll give you a little extra time, but if you could tell me specifically, first point is the approval of the students who are going to graduate. You want your client to be able to be in the room when the university or when the law school faculty approves the graduates. Is there anything else in your complaint that you want your client to be present for that in the factual record here shows that there was a delegation of authority other than the student graduation?
We mentioned in our brief the specific things that were discussed, including budget recommendations, budget committee reports, including how are we going to teach during the pandemic and questions of that sort, which all are questions of curriculum and administration of the curriculum among the students, Your Honor. So all of those things are matters that have been delegated to the faculty by FMU under the authorities that are cited in the brief, and that I will mention to you. Yes, sir.
One other quick question. Are you conceding that the dean isn't a proper party? I mean, if this all flows from on high from the board, not from the dean's office, then what role is the dean playing?
The dean was a person who excluded my client from the meetings, Your Honor. And as you know, as is pointed out in the briefs, Section 286.01 makes it a violation of the law for any person to violate the law.
So
and that brings us back to Judge Bilbrey's question that he asked me a moment ago. So she is a proper person. The remedy we really want is against FAMU. There's no question of that, if that's the issue.
Okay, so she's not a delegation person, she's an enforcement person. In other words, the delegation comes from the board down to the law school faculty, and the law school dean is the one that's keeping your client out of the meeting, so that's why you're including her.
That's correct, Your Honor. She's the person that's excluded.
Okay. Well, we've gone 2.5 minutes over, so we will give the other side
Thank you, Your Honor.
an additional 2.5 minutes. We'll give you 5 on rebuttal.
May it please the court, my name is Teresa Ward, and I'm here on behalf of the University of Florida A&M. I was thinking about this case last night, and I thought, what bothers me most about this? And I think it is the logical fallacy at work here. And I looked it up. It's called a non sequitur. It means it doesn't follow. And what doesn't follow is because the faculty is tasked with certain duties, they have to do it in the context of the monthly faculty meeting. They don't. In fact, the record includes, see what I'm saying? They don't have to do it in the context of those meetings. In fact,
I think that's dangerous territory, because let's assume for the sake of argument that they've been delegated authority to make some type of decision that would be subject to the public meetings law.
And
they can't do it by email, make the decision by email outside the context of the meeting and claim, well, we just did it by email, so therefore there wasn't a meeting. The meeting would be the email stream, wouldn't it?
I agree.
Okay.
And a person who did discovery in a case like this, instead of going straight to summary judgment, might ask for that. But in reality, the faculty has committees of their own. and the university has committees that do deal with, and the court took judicial notice of the law school handbook, and the law school handbook for the faculty says we have general faculty meetings and we have special meetings. Now, it's not really before the court because the record is closed now, but those special meetings may be open, and that was one of the points that the dean made to Ms. Janvier, that special meetings, rather than run-of-the-mill meetings, would be open if they're making those kinds of decisions.
But it seems to me that it's the substance of what goes on in the meeting that matters, not what you call it. You can call it a super special meeting, but if it's a meeting at which the laws apply or don't apply, that's the question. Now, the label doesn't.
No, but the assumption that is made by the appellant is that these faculty meetings, and especially these 3 faculty meetings, are where the duties of the faculty and the dean are carried out, and that's just simply not the case.
Well, if
There
the
are
meeting-
faculty meetings that are held otherwise, and there are curriculum committees and other committees. They're all in the handbook.
But aren't there official acts of the university undertaken at these meetings?
No, that's the point. The point that we have made is that the faculty staff meetings are for information gathering, and they are for the exchange of information reports. The budget report was mentioned. The other reports from the directors and so forth. If you look at the affidavit from the dean, the agenda shows reports were given. That's clearly factual information. That's
Deciding
not a
whether
decision
to-
making. I'm sorry?
Deciding whether to award a degree to someone, wouldn't that be an official?
Okay, well, I'm ready to address that. Again, what was entered into evidence by judicial notice at the request of the appellant was the FAMU Constitution. On page 480 of the record, which is a supplement, you will see that one of the offices of FAMU is the registrar. The office of the registrar shall be responsible for academic records of all students enrolled in the university, including admissions, credits, and grades, the granting of degrees, and official transcripts. We all know that a dispositive decision cannot be made by the faculty, especially in light of the fact that this is the beginning of their graduating semester. They can't decide at that point. They can't decide. I think the faculty needs to know that this list of potential graduates has been generated, because if they don't show up, if they didn't show up for the internship, whatever, the faculty should be put on notice. That doesn't make that dispositive. The other thing is, it's not an official act. If we go back to what the statute says and what the Constitution says, it says official acts. And it's not an official act on behalf of the university to say, these students are up for graduation, what do you think? And that's kind of what they're saying, because those same faculty will be asked at the end, did they show up and complete their classes?
Is it really like a comment period by the faculty during these meetings? Because, I mean, it seems kind of awkward. The faculty submit the grades, and the registrar tallies the grades and makes sure that they have the proper GPA and credits and certifies them for graduation. So I'm struggling a bit with, in this case, what the approval was by the faculty of the potential graduates.
Well, this is outside the record because we didn't really address it in the record, but I talked.
Well, let's not go
so
there then. I mean,
It's to say, are they showing up for class? Keep an eye on these kids. What if they don't show up their last semester? I mean, it's basically that. Be aware that these people are up for graduation.
Aren't some of these education records protected under federal
Yes,
law?
under FERPA, yes, they are. And that probably would be something that would be, as the student assessment is one of the other objectionable things. Student assessment would be a factual discussion, but it probably would be protected by federal law. Exactly. If a student is struggling, that doesn't need to be public.
Does your faculty vote on tenure for professors?
There is a committee for that.
Or new faculty?
Right. And in the record, in the law school faculty handbook, all those committees are outlined and what those committees are tasked to do.
Well, if they're fact-finding, it's one thing, but I guess what I'm getting at, is there any of these committees where they're tasked with making the decision or
Yes.
recommend?
Yes, in fact, for example, the curriculum committee. The curriculum committee is in the handbook.
Okay, then you can see those are open to the public.
Yes. Yes, yes. We're talking only, and the complaint in this case is only about the monthly faculty meeting, and in fact, it has been reduced to these 3 faculty meetings where there is no dispute of fact that And I want to go into why there's no dispute of fact, because I analyzed this. There's no dispute of fact because although it is a verified complaint, the paragraphs in that complaint that address the conclusion of the plaintiff that the duties of the faculty are carried out in the context of these 3 faculty meetings were not verified. She only verified, those paragraphs are actually paragraphs 41, 42, 47, 54, and she verified other paragraphs 6, 58 through 77, and 81 through 91. So we have an unverified complaint, allegation, and conclusion of law versus affidavits of the leadership of the university, and that's the record before the court, and that was the record before the lower court, that these are factual meetings.
Okay, so what I'm understanding, I'm hearing you saying, I want to be very clear on this. There are certain of the committees at the law school where they are making decisions about either tenure or new faculty. Those are open to the public, and Professor Little's client could attend those. But there's these other ones you're saying are more in the nature of fact-finding,
Yes.
and therefore are not open to the public.
It is going outside the record, and frankly,
Well,
I did
let's
not
not-
research that, but those things should be open because the faculty senate is open, for example.
Well, it's one thing for them to voluntarily make it open. It's another thing to be compelled under the public records laws to open the meetings, right?
Because I would say that they are because substantive decisions are made. And that is why I'm saying the non sequitur argument applies, because those decisions of substance are made in open committees where there's a discussion of the pros and cons and all that, and people can contribute.
Now, you said there were 3 areas, the student grades, budget, and what was the third one? That were in this case?
What was alleged
graduation,
was
right, yeah.
approving students for graduation, student assessment, and budget committee reports. I think the student assessment and budget committee reports are clearly factual. Approving students for graduation, I think some input at some point is going to be given by the professors under whom they studied, but it's not dispositive at all, and it only affects the student, not the public at large. So is it an official act that binds the people? You know, if you read the dicta of these cases about public records law, the dicta usually says, listen, the point of this is we don't want meetings in secret that affect a whole bunch of people in the state of Florida.
Well, okay, now, what about the agenda for the meeting or any, I mean, this is, as I've understood it, maybe I'm missing it here, this is an access to a public meeting case, not a public records case. So there can be, so some of the documents that are generated by Florida A&M Law School or the faculty committees possibly are public records, right?
True.
Okay, but that's not what this case is about.
No, because the public records that were requested were produced. We had gotten down to, she had to pay the $30 or something, and we just said, we'll just give it to you. So that count was dismissed. But the only issue here is whether or not these faculty meetings, and it was reduced basically, it kind of changed its character because it started out faculty senate in the complaint, and then it went into all faculty meetings in the complaint, and then it went into just these 3. So these 3 faculty meetings are fact-finding in nature. We have uncontroverted affidavits that say that from the university leadership, and they are entitled to the staff meeting exception of under the Florida Sunshine Law.
What about Dean Keller's party status?
You know, I would say most people will say in a complaint, in her official capacity or individually. And this complaint didn't say that. So I did research whether or not, I mean, did we learn in law school and agency what the assumption is? Probably the assumption is that she's sued individually. Now, she's not a board, commission, or agency, but she is kind of the gatekeeper. I understand that. I consider that point to be moot because of the reality that she was correct in saying that these particular faculty meetings are not open.
Well, I look at the style of the case and look at what I have in front of me. It's not the whole record, obviously, but the dean is sued as dean, it looks like.
Right.
Not
But
every-
usually people will say in her official capacity or individually. Now, when I first read it and went through it, my assumption was because she was identified as dean, that she was sued in her official capacity, and that means suing the Board of Trustees. And I think that's a fair assumption, but the word official capacity really is not in the complaint. I think she is being sued as dean. I think it's actually kind of a moot and a very small point. But
What does the record show as to what the faculty's powers were as to student graduations?
The rest of the Office of the Registrar delegation and the rest of the manual, which I don't think I can give you chapter and verse, but it's in here, deal with the fact that the registrar, in conjunction with the faculty and the provost and a whole bunch of other people, really have to make this decision about who is going to be a successful candidate for graduation, who's going to be awarded a degree. So,
But who ultimately makes that decision?
registrar. You know, my daughter happens to be an advisor for FSU, and it's always the grad check. It always goes to the registrar.
So let's say I'm a FAMU law student, and the faculty has discussed Scott Makar, a law student, and said, boy, he's not worthy of being a member of the bar. I don't think he should graduate. How does that get translated at the registrar's office? Or does it matter? I mean, I thought we
Right.
thought these things were pretty ministerial.
I don't think that kind of character assessment could be dispositive. I think that there would probably be someone in the registrar's office who said, he's met all the graduation requirements, and, you know, you just can't make that kind of a subjective assessment. Because that's not what the catalog is all about. The catalog is you enter under this series of requirements, and you meet these series of requirements, and you graduate. You know, if the
But
Florida
something-
Bar wants to make a character assessment based on its application, that's different.
But something comes out of this fact-finding process as to student graduations. What is it?
Well, as I said, what comes out is keep an eye on these, make sure they finish their course, make sure that they actually have been here, make sure there's no mistake in your attendance records. I would think the faculty should know these people are up for graduation and this is their final semester, but they can't in that meeting, they can't possibly make a dispositive decision because they haven't completed that semester.
Right.
So it's kind of an impossibility.
Counsel, if I could
Yes.
back you up a little bit, can you address the argument that the FAMU regulations and the ABA policy somehow elevate what the faculty is doing to a decision-making status? That because those regulations are there and the ABA policy is
I think it's a
there-
jurisdictional issue. I mean, the ABA has their jurisdiction, and they decide how they're going to accredit law schools, and that doesn't seem to be a question here. And the Florida Supreme Court has their jurisdiction about who they're going to admit, and that's another jurisdiction, really a separation of powers issue, because that they don't really make law. They decide who's going to be admitted to practice before Florida courts, and that's not really a force of law that the legislature has. It's not the same force of law that the legislature has created in Chapter 286. So I think it's a matter of jurisdiction, and I don't think it's not going to supersede what the legislature says.
If I could follow up, you said tenure committee meetings are open to the public.
I
Is that-
cannot,
in
I
the back of my
cannot
mind, I'm
guarantee
worried
that.
that doesn't.
But I do know that the voting is anonymous. But I do not know that those are open to the public. I don't know tenure, it's called tenure retention and promotion.
Okay, because what I wrote down was tenure and new hires, and I thought you
Now,
said.
new hires is different, yes. New hires have to go before a certain number of faculty, and they have to be voted on by the faculty. And that is in the handbook, that new hires. So that's different. Retention, promotion, and tenure, I know the vote is anonymous. I'm not going to guarantee that's an open meeting because you can see why. I mean, you know, the person who's up for promotion is going to be there, and you can't have that.
As
You
long
have-
as there's legal authority to make it anonymous, then you're
Right,
fine.
exactly. We're not before the court on that one right now, and I agree that's kind of a stickler. I just want to say that also generally, you know, the statutes say that they cover official acts made that are binding. You know, the elements seem to be, generally speaking, okay, a meeting where official acts are carried out with delegated authority, okay? So again, this faculty meeting is not necessarily where the faculty carries out its delegated functions. There are a lot of different committees that are set forth in these manuals that have been admitted to the record. And I invite you to take a look at those because they explain how this is actually done. And it's not done in the context of the monthly meeting, just get together what's going on. So again, I ask that you affirm the lower court and find that the staff meeting exception applies. Thank you.
Okay, thank you, counsel. Professor, we gave you the full 5 minutes.
Thank you, Your Honor. May it please the court. The FAMU has changed its position on a number of things. First of all, FAMU took the position that the faculty members are members of the staff, and the meetings of the board of the law faculty are fact-finding for the dean. Now, the fact is that faculty members are not members of the staff, but faculty members are the policy makers for the College of Law. You had asked me earlier, Your Honor, about where does the graduation requirement come from? And under the FAMU law matters, and not the law of the whole university, the registrar is just a recorder. But listen to this. The faculty of the College of Law, and I'm reading to you, and you can find this in the faculty handbook on page 183. The faculty of the College of Law shall determine academic policy and practice for the College of Law, including but not limited to the determination of curricula and the standards of admission to, continuation in, and graduation from the College of Law, the faculty's job. Now, in italics, and these are my italics, the faculty through the dean shall recommend candidates for degrees, shall recommend faculty candidates for degrees. That's the job of the faculty. If the faculty doesn't do it, it doesn't get done.
They're recommending, they're not granting the degrees. Does that
They're not.
little-
They don't have to
make a
be the
difference?
final decision maker, Your Honor.
But it's
All they have to do is they have to make a preliminary decision that forecloses the decision of the final grantor of the degrees. It is possible.
Counsel, the faculty could say, I don't want Joe Little to get a degree.
That's correct.
Okay.
It's possible that you mentioned Mr. McCarr. Could have been that the faculty approved Mr. McCarr for graduation. The president could have said, I ain't going to do it. I'm not going to let him graduate. Well, you would have had a good lawsuit if that had happened, probably. But that's the way it works, you see. This notion that the faculty doesn't have anything to do but check whether or not the students go to class is nowhere in the records that we have here. Here is another provision. And these are the regulations of FAMU, adopted by the Board of Trustees, either in the, or not by the trustees, either in the Constitution and bylaws or the law school handbook. The faculty has the following responsibilities: determining requirements for academic degrees granted by the college, arranging the curriculum, development of recruitment policy, and admission of students, granting or withholding academic degrees. This is a delegated authority to the faculty.
Let me ask you factually, if at one of these meetings one faculty member says something about a student that he or she's concerned with, that doesn't rise to a policy-making decision in public records, public meetings and all that, just because they comment on one student. If, however, the faculty votes on whether someone should graduate or not, I could see where that is an exercise of authority that would make it a public meeting. Again, what I'm saying is, like, if at this meeting, hey, anyone got any comments on the students? Well, 2 or 3 comments from professors about 2 or 3 students. That doesn't rise. That's not even fact finding. It's just commentary. But if the vote is taken up by the faculty on a particular matter, a recommendation, could be a recommendation or a final approval, that would be open to the public. Correct?
It would be, Your Honor, but a public meeting, under the law of Florida, a public meeting in which public business is to be held is open to the public. The meeting is open to the public, you see. And if in fact it's possible, as in regards to a city commission or a county commission, that we need to discuss litigation policy, it's possible that we can in fact go into a private session and follow the law on that and not have a public meeting. But if it's a public meeting, it's a public meeting. and the public is entitled to be present. Your Honor, there was the most recent public reading case came out of Collier County, and in that situation, the Board of Public Instruction of Collier County had been required to appoint a committee to recommend textbooks to the board. And a committee was appointed. We don't know who was on the committee. And it met in secret to recommend textbooks to the board. And the board took that recommendation and just adopted it as it was. And a lawsuit was brought. And the court held, the 3rd District Court of Appeal, held that the textbook committee had to meet in public, and it didn't meet in public. And therefore, the approval of the textbooks by the board was invalid under the Sunshine Laws. Now, there are 2 points here. Number one,
Make it quick, because you're...
it doesn't matter who is making the decision. If the authority to make the decision or a preliminary decision has been delegated to it. And that applies here as well. Your Honor, I have one other thing I'd like to ask you.
Quick.
Not having to do with this case.
10 seconds.
I look at all these pictures around here. Many of them are faded, not as much as my memory, but many of them are faded. It'd be very nice if we had we that are sitting here, had a form that could tell us who they are.
I thought you were going to say we need to get it restored.
Thank you.
Thank you. All right, counsel, the case is submitted. And we'll take just a moment to get the next folks teed up. I guess my portrait will stay here, huh? Yeah.
Be ready for us.
Harvey and me will be up on the ceiling.
Good question.
Okay, we next have the case of Sargent versus Bradford County Sheriff's Office, Florida League of Cities, case 21-2013. 15 minutes, is 15 aside? Yeah. So counsel, if you'd like to reserve some time for rebuttal, please do so.
Thank you. Good afternoon. My name is James Spears. I have the pleasure of representing Correctional Officer Stephen Sargent, and I would like to reserve 5 minutes for rebuttal. The facts of this case are not in dispute. However, I think a cursory overview of the salient facts is warranted as it really plays into the arguments that are being made here today. My client, Mr. Sargent, applied with the Sheriff's Office in January of 2012 for both the position of Sheriff, Law Enforcement Officer and Correctional Officer. That's in the record at 240. He had a pre-employment physical done by Dr. Giannis, who was an employee of the Sheriff's Office, had been an employee there for a long time, and had done these physicals for quite some time.
And this is for a part-time position, right?
Well, he applied for whatever position was open.
But what did he get?
I'm sorry?
He got a part-time position, that was my understanding.
Originally, he started as a part-time employee. That is correct.
Counsel, did he set up that pre-employment physical on his own? Who initiated that?
The employer did that.
Why? Under what authority?
Well, they have to by rule. And if you look at 11B 27.002 of the Florida Administrative Code, there's a requirement that mandates physical examinations for new employees, new hires.
So if he's transitioning from part-time to full-time, does he have any obligation of his own accord to go get a new physical?
The claimant, he does not. I mean, my position is that is the employer's responsibility. If they're going to be in compliance with the law, then my position and the appellant's position is that they're the ones who should set that up and schedule it if we're looking at this as a new employment, a completely new type of employment. But I dispute that that's actually what happened in this case. Because if you look at the facts of this case, yes, he started out as a part-time employee, as did half of the other correctional officers in that department. Okay, so this isn't just a singular issue relating to my client. This affects my client and half of the other correctional officers within that department who start off as part-time, given physicals at the direction of the employer, by an employee of the employer, a physician employee of the employer, and then transitioned administratively into a full-time position at some point thereafter.
Now, as I understand it, if Mr. Sargent was part-time, took the physical, passed it in 2012, and then say a year later he gets promoted to full-time, there could be an argument that under the law that he assumed the full-time correctional officer position under the previous physical examination. In other words, the previous physical examination would cover him because it's close in time. So he undertook the employment as full-time, and therefore the presumption would apply. But that's not what happened here, right?
Well, it depends on how you view the case. What happened was he started part-time. For about 5 months, he worked part-time hours. Mm-hmm. And then if you look at the record, he was a full-time employee for all intents and purposes, except for one thing. On the FDLE form, which Major Thompson testified to, the FDLE certification program, the box was checked part-time, not full-time. What does that mean? Absolutely nothing other than about $4 per hour in pay and benefits. No distinction whatsoever in the certification requirements, no distinction whatsoever for this employer as to the job required. Part-time, full-time, at that facility did the exact same job. That is clear in the record and undisputed.
Well, okay, so I'm trying to get clear in my mind what's at issue in this case because he passed the physical exam when he became a part-time correctional officer. He then worked hard, put in more hours. He was actually working full-time, although he wasn't technically a full-time correctional officer yet in 2013. And then in 2014, he actually got formally promoted.
Correct.
Full-time correctional officer. Okay.
That is correct.
Now, if he had just come in off the street and interviewed in 2014 and became a full-time correctional officer and he had a physical examination, we wouldn't be here, right?
We wouldn't be here.
Because right, okay. So the question now has become, did the original 2012 physical examination apply so that he gets the presumption, or was there some obligation of the statute for there to be another evaluation in 2014, I assume, when he became officially a full-time correctional officer?
Right, and that is the issue, and the issue was clarified and kind of narrowed in the order denying the motion for rehearing by the JCC in the proceedings below on the record at page 73, and he said the holding in this case is that the claimant was required to undergo a physical examination upon entering into full-time position as a correctional officer, saying that the claimant had to have a new physical once they formally, administratively, clicked that box and said, okay, now you're full-time. Even though you have been working full-time for almost a year with significant overtime hours, now officially you're full-time. And the judge says, the judge in the proceedings below said, okay, he should have had another physical at that point if he was going to be entitled to the benefit of the presumption statute. And that wasn't done. And the employer elected not to do that. And they chose not to do that. And they give specific reasons why they didn't do that. They didn't feel it was necessary.
Well,
That-
go ahead. No.
That gets into your waiver argument, then your third issue.
Yes, sir.
You below had talked a little bit about estoppel, but it doesn't seem like you're arguing estoppel here, just waiver. Is that correct?
Well, yeah, I mean, I think waiver is really the one that applies. I mean, when you get into estoppel, I mean, how can someone change their position if they don't even know that they have an issue?
So, well, isn't it the same thing with waiver? Waiver is an intentional relinquishment of a known right, and the testimony from Major Thompson, I think it was, is they didn't know anything about this, right?
Well, that's what he testified to, but ironically, we're talking about a law enforcement agency that employs law enforcement officers and correction officers claiming that we don't know the law. I mean, that's some significant irony there. And in addition to that, I think there is evidence in the record that they knew what was going on, because when this gentleman had his disabling cardiac event in 2020, they certainly knew to pick the case up and investigate it under the pay and investigate provisions. How did they know to do that if they didn't know about the law?
Well, so I mean, that would just be a competent substantial evidence who the JCC believed then, right, on that issue?
Well, I suppose it could be, which is another argument I raised, that CSC really, when you look at all the facts, just doesn't support the finding here.
I wasn't entirely clear on that, because the first issue you say we reviewed de novo. The second issue you say is CSC. Can you explain which
So,
it is?
yes, thank you. And my first argument is statutory interpretation. You know, you look at this and, you know, look at the applicable statute and the administrative code, which I think have to be looked at together. It was dismissed by the judge and is dismissed by appellees in their answer brief, but it wasn't really taken into account. That has to mean something. They're inextricably intertwined. The hiring process for a correctional officer and law enforcement officer is governed by the administrative code. And it says that you have to have that physical, which was done in this case and done on that form that is stated within that administrative code, has to be done within a year of appointment or employment. So if that's the case, my client was hired, had a physical. Physical was done May 31st of 2012. He starts to work full-time hours within 11 months. From that point forward, he's basically working full-time hours and overtime significantly. There's no question about that. Does that for a year, and then they decide to check the box and make him a full-time employee.
Well, let me ask you this, because I don't know the answer under the law, but when he became formally a full-time correctional officer, now let's say he knew that this case was going to come down the road, and he might have said, well, I want you to give me an examination now because I want the presumption, 8 years later. How does it work? But that doesn't seem sensical to me, because I don't think most employees are going to say, well, please test me. I just want the job. And he gave him the job, and the employer said, you don't have to have a test.
Right.
So who's the decision maker as to the examination for the purposes of the presumption?
The employer is, absolutely. The worker doesn't know about this. He's just following the orders that he's been told. He's saying, present for this pre-employment physical. Yes, sir, I did it. I passed it. Show up to work. Yes, sir, I'm here. I'm working. Works for some time, and then gets the benefit of the $4 extra per hour and benefits, and then is formally made a full-time employee. But we know in this particular case why they didn't do it. The record is clear. Major Thompson said, we didn't do a second physical because they'd been here with us. They'd been observed. They'd passed their first drug test. We knew they were widely capable from our previous experience with them. We didn't retest. We didn't do another test. That's on the record at 356. So they consciously made a decision not to give him a new physical.
Okay, so your position is that there's that evidence, I assume I don't know if it's unrebutted or not, but if that's the evidence, then they waived it. The employer waived it.
Absolutely.
Okay.
They had to have waived it because the testimony here is something that was not in Faust. Okay, Faust, this kind of testimony wasn't there. They were saying there was no evidence of that they knew of the statute or that they did anything to waive it. Here we have statements not only from Major Thompson but also from the doctor who did these physicals, who had been there quite a long time, who very clearly on page 312 of the record say it's not something they do. They don't retest unless someone leaves and comes back or they've been injured and comes back. Very limited situations, but they don't just retest when they make.
Let me get this in before your time's up. The statute does not mandate a new pre-employment physical under these facts, correct?
Statute?
The statute.
No, it's
about
not
the rule?
very clear on that.
What about the rule?
The rule says it has to be done within a year of appointment or employment.
But doesn't specifically distinguish new intake versus change of status.
It does not. And I'll reserve the rest of my time for rebuttal. Thank you.
Thank you, counsel.
May it please the court. My name is Steve Coonrod. I represent the Bradford County Sheriff's Office and the Florida League of Cities. Just a brief background. When this claim was received by the League of Cities, it was accepted as compensable under the pay and investigate provisions. Benefits were provided, investigation was conducted to determine whether the elements of the presumption should apply. Mr. Sargent returned to work, receiving indemnity impairment benefits when the denial was filed, and that's led us to this litigation today. Now, during the 120-day investigation, what was learned was that while there was a pre-employment physical, it was not conducted upon entering into service as a covered employee. 941.10 subsection 2 defines correctional officer. While there are many officers, only a select few are entitled to the presumption. And the presumption requirement, the physical requirement, is not in 112.18 for correctional officers. It's in 943.13 subsection 6. And what that section says is that a physical, as required by this subsection, must be completed and fail to reveal any evidence of heart disease, which is applicable in this case, upon entering into service as a correctional officer. It is specific statutory definition. Florida Department of Law Enforcement has a global profile sheet that tells us exactly when part-time status began and when the full-time status began.
What I'm struggling with is when Mr. Sargent is now becoming a full-time employee formally, and the employer says, well, no, don't bother. The statute says to get the presumption we have to do all this and have new, but forget it, just get to work. Why isn't that a waiver?
Because that's not exactly what the testimony was. The testimony consistently was no one even thought about the presumption. No one thought about a physical at that time. Nothing was ever promised. There was no knowing waiver of a right. What happened was they didn't send him for another physical. Under the statute, a physical has to be conducted upon entering into the covered employment. That didn't happen here. And I can address...
I'm sorry to interrupt. Who controls the decision about whether a physical is going to be
And
done?
that's exactly what I'm getting to, Judge.
Okay. Thank you.
It's what happened here is a physical should have been done. It wasn't done. It wasn't done by the employer, not because of some plan or a scheme or calculation or any knowing effort to impact the presumption in any fashion. It just wasn't done. And the question becomes, how is this like Cumbie and the Faust case and even the Hubbard case, where similar situations all went down, all happened? And what we're dealing with here, I think the ultimate issue we're dealing with is what is the role of the workers' compensation system when the statutorily required element is not present, that is, the physical which failed to reveal any evidence of heart disease. That's not present here.
But can I get you on this one point?
Yeah.
Keep your thought. But can't the employer waive that statutory required element?
I don't think they can,
I mean, the statute says this must be done, but as I understand, a waiver argument is, well, yeah, it must be done, but we, the employer, don't need to do it. You don't need to do it.
Yeah, that's it's an excellent question, and it's one of the cruxes of the case. I don't see how an employer can waive a statutory element of the presumption any more than they can say that they're going to expand the presumption to other classes of employees. But if waiver did apply, it would have to be a knowing waiver. It would have to be a knowing relinquishment of that right. And simply saying we don't send people for other physicals because they look okay to us is hardly a knowing waiver of a right to have that physical in order for the presumption statute to properly apply. So that's the difference.
No,
Could
but-
there be a set? I'm sorry. Go
But
ahead.
couldn't it be, I mean, if you assume, and this is, in the law, we always assume people know the law and employers know the law. I'm the employer, and I know I have to give a physical now on this, for this presumption, and I decide not to give it. Why isn't that in and of itself, a waiver?
The employer in this case didn't know. Now, if you're making a hypothetical, what if the employer does know and decides not to do it? Well, then they're in violation of the Criminal Justice Standards Commission regulations, and that's where that would be regulated. And the consequence of them not sending somebody for a physical when they're supposed to, it still didn't happen. And I think that's a legislative matter. There's a bill pending now, which I can find the site for, where that exact subject is being discussed and debated by the legislature, and that's the place for it. There's not a remedy for this in the statute. There's not a waiver provision in the
So
statute.
basically, the sheriff's office gets the benefit of their own failure to follow the law, is what you're saying.
Well,
as opposed to the $15 an hour or $12 an hour employee going to $15 an hour employee, we're letting the sheriff off the hook, and with that, half of the COs there are also not going to get the heart-lung presumption.
Well, there's 2 points there. There is a distinction beyond just the $4 an hour between part-time and full-time, although the real point I want to make is we don't know that anybody gets. The question here is fairness, right? It's not fair, but for the timing of this physical, the presumption would not apply. We don't know what the physical would have shown. And as far as
So
other,
it should have been on the sheriff to ask for the physical, because had he exhibited some heart disease at that point, you're off the hook.
well, yeah, when you say we're off the hook, perhaps, because Mr. Sargent still has the ability, like everyone else who's an employee, who feels they have a work-related illness or injury, to
Well, you don't get
establish that's actually
the heart-lung
work-related.
presumption, which is the majority of these claims, goes by
Right.
the wayside, right?
It goes by the wayside if any of the 4 statutory elements are not present. Now, again, this is a question of whether the court fashions. As I see it, there's only 2 ways to get around the fact that the presumption did not apply if you look at the text of the statute, the plain reading. Either the first is you assume that the 2-year-old physical, which showed no evidence of heart disease, can be applied to make the presumption 2 years later, or you say that we're going to fashion some type of remedy, some sort of punishment on the employer because they, not willfully, not because they were trying to get around the presumption, but simply because they weren't up on all the requirements of 943.13 subsection 7. And it is undisputed that that physical didn't take place. We have no safeguard to establish that there was an absence of any evidence of
I
heart
have a
disease.
bit of a concern because it seems like this physical should have been done. The employer, for whatever reason, inadvertence or
Yeah.
otherwise, didn't do it. I mean, what if it was a fingerprint requirement? You have to have fingerprints before undertaking, getting this job. And, don't bother. I mean, it's a statutory requirement or it's not, and it can be waived or it's not. So I'm struggling with that concept.
Well, it's a statutory element for the presumption, but as far as the fingerprint requirements, there's, I think, if you look at the rule that was cited, that governs the employment of all officers, regardless of whether it's covered or not, there's a whole list of things that are supposed to be done during that time, including citizenship verification, various other things, background checks. And what is the role of the workers' compensation system if one of those is not followed or completed? And what I'm arguing is that's not the workers' compensation system's role. That's the role of the Criminal Justice Standards Commission to regulate that. And as to the effect that some omission, that the Bradford County Sheriff's Office, I just think of the way the statutes have grown since I've gotten out of law school. Yes, criminal law, you would expect the Sheriff's Office to know that. But given this volume of laws out there, workers' comp, employment law, is it preposterous that they would not be aware of this? Of course not. There was no willful or harmful intent on their part.
Counsel,
It just wasn't done.
Let me
Yeah.
interrupt with a preservation question. Do you think that the claimant preserved the specific argument that the employer failed to comply with law? Is that the same as waiver estoppel? Or is it a separate argument to say the statute and the rule require it and they violated those?
Yeah,
Preservation question.
Yeah, right. In the briefs, the idea that there was a noncompliance with the law was raised, but the argument of noncompliance with the law in the underlying matter, I don't think was explicitly raised. The issue was whether there was a waiver. There was discussion.
And is there a qualitative difference between those two arguments under a preservation analysis? Is the waiver estoppel broad enough to encompass the other argument?
Yeah. It's a good
Could be
question, and
important.
I wish I had a great answer for you. And if I went back and reread that whole transcript to address that, I could do better. I feel like I wouldn't be doing justice to opposing counsel if I said definitely one way or another on that particular answer
Thank
or
you.
question. So, just wrapping. Well, it looks like I have a little bit more time left.
Well, is it your contention that, FOP or some other agency, union for the employers should have been the one to say, hey, wait, you're moving from full-time to full-time from part-time. you're supposed to go get a test, go insist on a test? I mean, the burden should be on the employee, not the employer, when there's a mistake?
As far as when there's a mistake, I'm not sure who the burden is on. It's the employer you would expect to schedule this physical. The employee has every right to do that, but it's important to note that there was no discussion of this, no contemplation of the presumption during any of this process. And that's why the arguments of waiver or estoppel really aren't applicable here. If I could just touch on, there is case law on this subject, and whether we go all the way back to the Cumbie case where you dealt with a firefighter who did not have a physical exam until 2 years after he entered into cover employment, what the court concluded, the majority was, it's not the role of the appellate court to amend or revise a statute. In the dissent in that case, there was even a reference by, I believe, Judge Urban, going back to an Industrial Relations Commission case from the 70s with the same ruling. Then we go on to the Faust case. Same situation. There is an obligation when you enter into a new appointment under the rule for there to be a pre-employment physical. And that didn't occur in Faust. And again, the presumption was found not to apply because the 4 elements weren't present. There's also the Hubbard v. the City of Homestead case, which dealt with literally the same facts, same time period after the presumption applied to law enforcement and corrections. That is a PCA, though, so I acknowledge that. But again, at the end of the day, what we're coming down to...
Can I ask you about Cumbie? Is it perhaps distinguishable because we're dealing with a fireman there? And I don't know the requirements for certification of a fireman, but certainly 943.13 wouldn't apply because that's certification of various law enforcement officials.
There is a distinction for firefighters in the presumption statute when it comes to the reverse presumption. And I think there's a case coming up on that shortly. I'm not sure of the panel. But otherwise, there's not a distinction when it comes to the requirement for a physical upon entering into service. Now, under the firefighter and corrections officer, I believe it says into such service, but it really doesn't matter because
that's the 112.18.
112.18, then 943.13, subsection 6. They all require that physical to be conducted upon entering into such service because you have this presumption. You're presuming a common health problem is work-related, even the evidence, in the absence of any evidence that it is. So is this court the place to fashion a remedy when the legislature hasn't? Or is this something to allow the legislature to address through their debate, through our elected representatives?
Well, do we have any case directly, factually analogous to here? Because Faust, I was on the panel in Faust.
Yes, sir.
The distinction that was made there was that at the time the employee began employment, there was no requirement to have a physical examination. So therefore, the employer couldn't have intentionally waived that right because there was no obligation to have a test.
Right.
So that case is factually distinguishable from here.
Well, I think that sentence came 1 or 2 sentences after this, the qualifier, that we're not even going to reach the question of whether waiver is something that the employer can do with regard to this. If I remember correctly on that, I'm probably paraphrasing. The Hubbard case is directly factual at that point, but again, it is a PCA. I was told here at a seminar a couple weeks ago that a good oral argument is a conversation. So I think we've had a good conversation on this. Are there any other points you'd like me to address, such as the idea that working more hours in a part-time capacity turns you into a full-time employee?
If you want to create more issues, that's fine. But
let me just touch on that briefly.
Sure.
Captain Starling had pointed out that the part-time force is used as a relief force. It's used as needed. So what you have, and all right, good, 57 seconds, I can knock that out in this. The part-time officers were brought in if they need the extra help. Now, Mr. Sargent, he has his pre-employment physical. 7 months later, he enters into employment as a part-time employee. 5 months after that, working as little as 3 or 4 hours a week sometimes, his hours start to increase. And the reason is, as Captain Starling said, this was a matter of need. This was not a set schedule. We just had more need. So it doesn't turn him into a retroactively constructive full-time officer. I mean, that designation's done by the state. And as we've talked about, I really think this is a question of where does this remedy for this event lay? And I would argue it's with the legislature. Thank you all very much. I request that the order by Judge Holly be affirmed.
Thank you, counsel. Rebuttal.
Thank you.
I mean, before, keep your thought, but you rattle off a set of facts early on about how the employer said, oh, we don't need to have this test or evaluate. Where is that in the record?
It is,
Was this some testimony of a,
it's a testimony of Major Thompson, who was in charge of administration of the jail.
okay, we'll track it down.
Yeah, and I can give you the citations for that.
Yeah, don't burn up your time on it. We can always find it.
Okay. One thing I wanted to point out is that once Mr. Sargent began working for this employer, he didn't work anywhere else. He worked continuously for this employer the entire time, all the way up until he had his cardiac event. What the sheriff's office is doing here is making hyper-technical arguments, and I'm brought back to the Carpentieri case, which dealt with a different issue of the presumption, but had a very good finding and quote that I think is appropriate here. To deny Carpentieri the benefit of the presumption based on the EC's narrow construction of the statute would not only be grossly unfair, but would also be contrary to what we believe the intent and purpose of the statute itself is. How is Mr. Sargent supposed to know when they decide to make him a full-time employee that, oh, can you please give me a new physical? Even though that's the law that they should follow, it's not his burden to do it. I mean, this is something that an employer, certainly an employing agency of law enforcement officers, whose job it is to enforce the law, should know and require.
Well, couldn't the same thing be said about Cumbie? I mean, it's an old case, but it's binding on us, and for better or worse, you know, he didn't have the physical there when the law changed. Nobody told him, and two judges on the panel said he's out of luck. I mean, how do you get around that?
Well, in Cumbie, they didn't even give him the physical until 2 years after he started. So that's clearly distinguishable. Here, we had the physical before he started working for this employer and worked for them exclusively from the date of hire until the date he had his cardiac event. So I think that's easily distinguishable. So what we have here, if you look at, and this is the problem, you know, we're here with the Sheriff's Department, the Florida League of Cities. People are watching this. This order gives a roadmap into how you can avoid responsibility for a legislatively mandated benefit. And like I said, it affects my client, it affects half of the correctional officers in this department. And the way that it is done, in actuality, in the actual result, it allows the employer to decide who does and who doesn't get the benefit of the presumption. Because half of their correctional officers, they said, okay, we'll give you a physical when you start full-time. Half of them, we're going to start you full-time, and then at some point afterwards, we'll make you full-time, but we're not going to give you another physical, so you're out of luck. That can't be the way that this law is interpreted. It just
Counsel,
can't.
could you address my preservation argument also? Did you preserve the specific argument based in the requirement, affirmative duty of the employing agency under the statute and the rule? Is your waiver estoppel argument the same as an argument that because the agency or the employer has the statutory obligation and the rule obligation to initiate the physical, they failed to do it at their peril? Preservation.
Well, yeah, I think so. I mean, that argument was made, the waiver argument was made, the argument about the statute and administrative code rule was made. I mean, I think it's all one and the same. I don't think those are two separate arguments. I think they kind of go together. And it's just evidence of how there was a waiver. Because the requirement was in place, they gave specific testimony as to why they didn't do it, which we didn't have in Faust, which was another reason why it's distinguishable. And despite that, they just didn't do it. They did not do it. So we would ask that the JCC be reversed on this issue. Thank you for your time.
Okay, counsel, thank you both. We will now be in recess.
All rise.